Welcome to The Free Will Show, a podcast that provides a beginner-friendly introduction to free will while also exploring cutting-edge developments on the topic. I'm Taylor Sear.
And I'm Matt Flummer. In this episode, we talk with Mihailis Diamantis about the nature of corporations and similarities between corporate and individual criminal responsibility.
Thanks for listening. I'm happy to introduce Mihailis Diamantis, Ben V. Willey Professor in Excellence at the University of Iowa, where he has appointments in the College of Law and in the Department of Philosophy. Mihailis works on several issues at the intersection of philosophy and law and is widely published, but his main focus recently has been on corporate criminal responsibility. And so we've asked him to join us today to talk about the agency and responsibility of groups, focusing on the criminal responsibility of corporations in particular. So thanks so much for joining us, Mihailis. Could you start by telling us a bit about yourself, your work, how you came to be interested in working on issues related to responsibility and the law?
Yeah, sure thing. And let me just say, Taylor and Matt, thank you for having me on the show. So looking forward to our conversation.
Yeah.
Good to have you.
I teach in a law school. I have a courtesy appointment in philosophy, got JD and PhD, and I like to think of all my work as being either legally inspired and philosophically inflected, or legally inflected and philosophically inspired. But as you mentioned, the core of my work right now is on corporate criminality. I would put it as theoretical issues in corporate crime. And I just think there's a lot of unexplored territory in investigating what it is we're trying to do with our corporate criminal system, thinking about what alternatives could be, what mechanisms might be available to us. I just think philosophy has a lot of conceptual space to open up for academics and practitioners of corporate crime.
Mm-hmm.
When I was in grad school in philosophy, and even when I was in law school, I never had any ambitions in the law.
Okay.
Law was like pretty much a concession to my parents. It was a stopping point to get a JD on my way to the PhD. When I told my parents I wanted to be a philosopher, I think their hearts sank. They were both entrepreneurs. Like, I want you to do something pragmatic. And, they would say pragmatic and rub their fingers on each other in the dollar, the dollar sign. But after law school, started grad school in philosophy and put grad school on pause for a couple of years, and another concession to my parents to tell them, look, I'm a good son. I'll put in a couple years at a law firm and test it out. And I went there with an open heart. I went there to do, of all things, international arbitration, very unphilosophical discipline. And while I was there, my firm decided that it was wanting to build out its white-collar defense practice. And so I had what I thought at the time was the grave misfortune of being assigned away from international arbitration to a team that was conducting corporate internal investigations on residential mortgage-backed securities. And even that sentence, people start snoozing. And so, I spent 18 months, 2 years doing investigative work for corporations. I never really saw the bigger picture of it. But things for me really changed when a colleague was working on another case representing a manufacturer. The manufacturer had designed some products that were faulty and ended up killing some people. These were car parts. And just it was casual conversation over lunch or coffee or something, and she was wringing her hands over a research memo that she'd been asked to write. And the research memo was, can a corporation be at fault if none of the individuals in the corporation did anything wrong?
Yeah.
And in particular, she was focused in this case on negligence. Can a corporation be negligent if no individual in the corporation is negligent? And that just set firecrackers off in my head. And so that was eating a hole in my ear and my brain for 2-3 years until I produced my first real paper on corporate crime, which is Corporate Criminal Minds. And it's an effort to understand what is an acceptable and productive and defensible view of how to establish corporate fault. And in the course of investigating and writing this paper, I came to realize that philosophy can do a lot to advance the understandings in corporate law, and in particular understandings of corporate responsibility.
Yeah.
I will say, after researching in that trajectory for several years, I now get really excited when I can see ways that understandings of corporate legal responsibility can reflect back and give us some insights into what individual responsibility is,
Mm-hmm.
at least in the law. And then when conceptions of legal responsibility, I think, hold insights back again to the philosophical understanding of,
Right.
of individual responsibility.
Mm-hmm.
And just a quick plug for the book we were talking about earlier. This is kind of the theme of a book that I'm writing, which is The Law and Philosophy of the Corporate Person, coming out hopefully at some point, not too long, in Cambridge, and their Elements of the Philosophy of Law series. And it's all about laying out parallel philosophical and legal understandings of various issues at the center of corporate responsibility, and talking about how both disciplines are better after they've spoken to each other than
Yeah.
when they're siloed, talking among themselves.
Yeah, very cool.
It is very
Sometimes
cool.
all it takes is just to have the right question.
That's right.
Before we ask you about criminal responsibility for corporations, we want to ask some more basic questions about the nature of corporations and corporate crime. What are corporations as the law understands them, and how pervasive are they?
Good. So I think it's really important to understand what corporations are, how they're structured, and how they operate, if we're going to talk about corporations in philosophy. And a lot of philosophers like to talk about corporations, people who work in business ethics, people who work in group agency and group responsibility, the for-profit large corporation, the thing we're familiar with today, Walmart, McDonald's, Target, BP, right? Those are the leading examples that they have of corporate agency, and the leading examples they use to assess what it means for a corporation to be responsible. And I think to have those conversations in an informed and productive way, it's really important to understand what corporations are. And I'm not persuaded that all philosophers, particularly philosophers that don't have a legal background, are well versed in what corporations are. I sometimes see, for example, um, philosophers treating members of the boards of directors and officers of the corporation as being interchangeable, but they have different and importantly different roles within a corporation. Just to back up a little bit, the corporate form, or some variant of the corporate form, has been around for a long time. I have a colleague who writes about, his name is Sergio Gramito. He writes about the corporate form in Rome. And so he traces out different types of corporations that existed all the way back in Roman times. The modern corporate form is a really transformative economic technology. It arose in the US and the UK, and a lot of people attribute the West's rise to economic dominance in the 20th century in large part to the corporate form. Now, when we talk about corporations today, there are all sorts of corporations. They all have different forms and structures as for-profit and nonprofit and benefits corporations. And these all have importantly different structures, but most of the literature in law and most of the literature in philosophy is focused on these large, publicly traded for-profit corporations.
Right.
There are other ways to carry out profitable businesses. You can have a partnership or an LLC or a sole proprietorship, and the for-profit corporation is one particular entity that the law recognizes for carrying on business operations.
Mm-hmm.
And the corporate form, it has some important features. One thing it has a corporate charter. Charter is like a document, kind of like the constitution of the
Yeah.
corporation. It lays out its basic organizational structure and states what the corporation's purpose is. And typically, the purpose in a corporate charter is going to be, and this is a direct quote, any lawful activity. The thought being there that it allows the corporation to pursue and pivot as the economic winds change,
Mm-hmm.
to pursue any sort of business activity that will maximize profits. Who are the profits for? And this gets to the second important feature of the corporate form, which is shareholders. Corporations are a way to pool assets, to allow the undertaking of massive projects that individuals could not otherwise undertake themselves. And so shareholders, there can be 10 of them, there can be 1,000,000 of them, they can all be in the same city, or they can be spread across the world. But it allows all of them to pool their assets together in a common enterprise for an ambitious project. A third important feature of the corporate form is what scholars call the separation of ownership and control. So the shareholders are the people who are paying money into the corporate enterprise. So they are basically funding it. In exchange, they get an interest in the corporation. So they, in a sense, own the corporation. When the corporation turns a profit, some of that profit gets paid back out to the shareholders. Now, the shareholders are not the people who run the corporation. They just contribute the capital to it. Instead, there's a series of structures of individuals who run the corporation on the shareholders' behalf, who control its operations. The shareholders elect a board of directors. These are a group of individuals who make high-level strategic decisions on behalf of the corporation. The board of directors nominates the officers. These are the individuals who, you've heard of them, chief executive officer, chief compliance officer, chief financial officer, who are in charge of running the day-to-day operations of the corporation, and who in turn hire all the different levels of employees in the corporation who run the corporation's business. Shareholders contribute the assets, but the officers and the directors control the corporation. A fourth important attribute, an innovation of the corporate form, is limited liability. This becomes really important in corporate criminal law. Shareholders are only liable to the extent of their investment in the corporation. So if they've contributed, let's say, $100, they're never going to lose more than $100 on account of the corporation's activities. So if a corporation accrues a lot of debts that it can't pay, the creditors are only going to get that $100. They can never go back to the shareholder to get more money. Importantly for corporate crime, it is the corporation that is prosecuted and never the shareholders for the corporation's crime. So it blocks financial responsibility, and the corporate form also shields shareholders from moral responsibility in the criminal law. Mm-hmm. You asked also just how pervasive corporations are. Well, I mean, you're all familiar with corporations. You bump into them all the time. If you reach into your pocket and pull out your wallet, you're probably going to see, I don't know, at least 5 or 6 different corporate logos in there. I know that I do. There are around 6 million corporations in the United States. Most of them are incorporated in the state of Delaware. They account for the bulk of our nation's GDP. And near and dear to my heart, thinking about it in terms of criminality, corporations play an even more outsized role when it comes to the economic burdens of crime. So, according to best estimates coming from the FBI, if you take all the street crime that occurs in the United States and add up its economic effects, it comes to somewhere around $15 or $16 billion. If you take all the economic effects of corporate and white-collar crime and bundle it together, it is 20 times that, $600 billion. Wow. So in the criminal world, extremely pervasive.
Right.
Yeah. Why are they all in Delaware?
They're in Delaware because part of it has to do with history, but there's a lot of discussion about why Delaware. So basically, states compete with each other to have the most attractive corporate law. What dimensions do they compete on? They compete to have provisions that are beneficial to the individuals in a corporation who get to make the decisions about where the corporation incorporates. So that would be the officers and directors of the corporation. So Delaware is favorable to those parties. The main reason, though, and the most compelling reason that I hear about why they go to Delaware is just Delaware is so good. So good because their judges are very well versed in corporate law. So Delaware Court of Chancery, which is the court which resolves issues about of corporate law in Delaware, is very highly respected. Well, not only within the United States, but across the world. And so by incorporating in Delaware, you get access to these really sophisticated judges to resolve your internal disputes.
Interesting.
That is interesting. Well, you mentioned a lot of different people talking through the form of corporation, but probably our listeners have also heard this expression that corporations are people, or corporations are people too. So I wanted to ask about that. What exactly does that mean, and why is this expression important for understanding the law, corporate law?
Yeah. So I think it was maybe Mitt Romney. Didn't he say it, like, was it 2016?
I think that's
Corporations
right.
are my friend. Corporations are people too. And
Yeah.
I think he's got a law background, and as a matter of law, he's right. As a matter of philosophical reflection, that's open for discussion.
Right.
Um, in philosophy of law, people understand the term person or legal person to refer to anything that can bear rights and responsibilities,
Hmm.
or at least bear, I think, rights. Some people talk about, I think it has to be rights and responsibilities. Some people think of there's certain um, ecological features that have been said to have been granted personhood status under various legal codes in, I think, Ecuador and Australia, and some people are working to do similar things here in the United States at the municipal level, meaning that they have various rights that people can exercise on their behalf to protect them from developers, for example. But as a general matter, in philosophy, for jurisprudential terms, legal person is a bearer of, let's say, rights and responsibilities. In terms of statutory law, what it means is that if you go to the first section of the US Code, it's a thing called the Dictionary Act, and it sets out kind of default definitions for terms in statutes. And if you look up the word person, it includes, and I'm going to paraphrase the definition here, but like natural person, which means human beings like
Hmm.
me and you, and also business organizations, including corporations. So it's explicitly defined in law that when they use the word person, unless there's some other alternate definition that's in play, it includes corporations. So that means anytime you see in a constitutional provision or in a statutory scheme the word person, you understand it to mean not just me and you, but also all the corporations that we know and love. Critically, for my area in corporate crime, this understanding of corporations as being people is the reason that corporate criminal law can exist. Corporate criminal law is not a different area of law. It is the same law that applies to all of us, to individuals. It has been extended to corporations by defining corporations to be people.
Hmm.
So whenever a criminal code says any person who does X is guilty of a felony or misdemeanor or what have you, that is read to include corporation. And that is why corporations are subject to the criminal law. One way to understand how corporations became people in this sense is that it's a product of legislative laziness. That Congress and legislators and judges, they had an option. You could draft an entire new criminal code that specifically defines crimes for corporations. That's a big legislative undertaking.
Right.
Another thing you can do is just find an easy trick to apply all the existing criminal code to corporations themselves, and you do that by saying, oh, every time we said person, for these hundreds of years, we now mean corporation as well.
Right.
Is it
The
really
se-
laziness, or is it just working smarter and not harder?
Well, there we go. Yeah, I think there's a lot of value to recognizing corporations as people in criminal law, and this kind of gets to the second reason, a second understanding, or it's not necessarily incompatible with the first understanding, but a second understanding of what's going on when we
Hmm.
recognize corporations as people, and that what it's doing is it's the law reflecting this prevalent psychological disposition we have to regard corporations as agents just like natural people are agents.
Yeah.
Cognitive scientists have done a lot of research into this. It's a property of integrated organizations like corporations called entitativity. And when we encounter, us as human beings encounter an entitative group, we are cognitively predisposed to regard it as though it is, and the role that it plays in our cognitive economy is as though it were another agent, capable of bearing rights, bearing responsibilities, and importantly from our area, becomes an apt psychological object for blame and praise.
Hmm.
Hmm.
So that's another way to think about what's going on when we call corporations people in the law. It's just paying homage to this feature of our collective psychology.
Mm-hmm.
Yeah, this is a good segue to talk about the nature of group agency. The way you've defined or explained the understanding of corporations, how is this going to be different from what, like, say, a philosopher says about group agency? And do you think that the philosophy of collective agency might be helpful when it comes to issues in the law?
Yeah. In law and in a lot of people, for a lot of people who talk about group agency, both individuals and corporations are agents. But I think the comparison between the legal and philosophical approaches to corporate agency basically stopped there.
Oh,
wow. In the law, agent, it kind of fulfills this functional role, this label
Mm-hmm.
that engages these other statutes to apply to corporations as well. They don't necessarily mean anything deep and robust by agency or person in the way that philosophers who use that term would mean them. Among philosophers of collective agency, they have deep, meaningful, and in some cases compelling views
Mm-hmm.
about what it means for a collection to be an agent. I'm not persuaded by any of them, but you have like people who have interpretivist approaches, following in Dennett's footsteps. They see a corporation behaving in a particular way and interpret it as though it is an agent, and if it's interpretable as an agent for them, and sometimes the locution here can vary with the philosopher. Let's just say it is an agent if it's interpretable as being an agent. You have structuralist approaches from people like Peter French, who say, well, a corporate agent is something which has a recognizable decision procedure.
Mm-hmm.
And if you have the right sort of decision procedure, you can point out to what corporate intentions are. And this is a way of building up from the corporate structure an understanding of what corporate agency is. All the philosophers are trying to understand how corporate agency can arise from the kinds of the relationships between the individuals that I said earlier compose the corporation. The law's understanding of corporate agency is extremely thin.
Mm-hmm.
It is basically entirely reduced to the agency of its employees. There's nothing arising from the relationships of the employees or from multiple employees together. You understand corporate agency just by zooming in on some employee and focusing on the agency of that employee. It ties back. I mentioned that there was versions of the corporate form back in Rome. There's this Roman doctrine called respondeat superior, which is today in federal law the way that we recognize corporate agency and responsibility. We say a corporate does all and only the things that its individual employees do. And so very, very thin notion there.
Mm-hmm. Well, last season of the podcast, where we've spent 10 episodes kind of focusing in on issues of philosophy of law, issues in the law more generally, and issues in free will and moral responsibility, we talked with Craig Ayul about mens rea requirements in the criminal law. And we were, of course, focused there on crimes committed by individuals. But now that we're talking to you about corporate criminal law, is there the same sort of actus reus versus mens rea distinction when it comes to corporate crimes?
There is. And if it's okay, I'm going to give a quick refresher for people who listen. You should go listen to Craig's interview if you haven't yet. But just a quick refresher on actus reus, mens rea distinction, because I literally just taught it to my criminal law class. Actus reus means the harmful act element of a crime. Mens rea means the culpable mind element of a crime. So, for example, first-degree murder is defined as killing with malice aforethought. To be guilty of first-degree murder, you have to commit the actus reus, killing someone, and you have to have the mens rea, malice aforethought. The reason we have mens rea is because, well, we don't think that all killings are criminal. Sometimes you can cause someone's death in a way that should not subject you to criminal liability. Perhaps the person stumbled out into oncoming traffic and your car hit them. Assuming that you were paying attention, it was the other person's fault. You still killed them, but we don't think you should be criminally liable. You didn't do it with malice aforethought. Now, for corporations, your question was, do corporations in corporate criminal law, do we have the same distinction between actus reus and mens rea? And I think from the response I gave to your last question, you can anticipate the answer. It is yes. It is the exact same criminal statute that applies to individuals and to corporations. So first-degree murder for a corporation is also going to be killing with malice aforethought. And so you got to ask two questions if you're going to hold the corporation liable. Prosecutor has to prove that the corporation killed someone and that the corporation had malice aforethought. How do we figure out whether a corporation engaged in killing someone and at that time had malice aforethought? Well, here's where we go back to that Roman doctrine of respondeat superior. We ask whether there was an individual employee within the corporation who killed with malice aforethought. And that's how we attribute it to the corporation, is through that doctrine of respondeat superior. And this mechanism, this way that we define mens rea and actus reus within a corporation, can lead to some interesting inconsistencies. So individuals in corporations, they don't necessarily all agree with each other about what to do. It's a group. Like, people can act at cross purposes to each other. So you can have one individual in a corporation who is killing someone with a malice aforethought, and another individual in a corporation who's doing everything they can to save the person's life. And one at the same time, the corporation is both killing that person and saving that person's life, according to respondeat superior. That's a actus reus kind of inconsistency. You get a similar sort of thing with mens rea. This is an example. It's not a criminal law example, but one that I like to use. This comes from like a employment law. You could imagine a hiring committee. People talk about hiring committees all the time in literature on collective agency, usually philosophy hiring committees, but this is going to be a corporate hiring committee. A hiring committee, and you can imagine it's got three members, one of whom wants to discriminate amongst candidates in favor of men. A second of whom wants to discriminate against candidates in favor of women. And a third of whom is doing everything they can to make sure that men and women are treated equally. This corporation, under respondeat superior, is both purposely discriminating against men, purposely discriminating in favor of men, and purposely doing everything it can to treat men equally with women. That's a bizarre result. It doesn't seem to resonate for some reason with lawyers, but I think to philosophers who come and look at the law's understanding of corporate mens rea, it's an immediate problem, which lawyers and legal academics have yet to address.
Yeah. So is there a further condition, I guess one difference between corporations and individuals? The person committing the crime has to be doing the crime as a representative of the company. So we're not going to hold the company responsible for some random action that was taken while the guy was on his vacation.
That's right. I love this question because you're kind of in the mindset right now about something that I think is really important for corporate laws, about how do you set the right incentives. You want to make sure corporation is only being pressured to control what it can control, and it can't control a guy who's on vacation. This gets into some of the weeds about respondeat superior. So technically, respondeat superior has two elements. As I stated it, as the corporation is responsible for what the employees do. It's only responsible for what employees do while the employee is acting within the scope of their employment, and while the employee has some, at least peripheral and possibly even hypothetical, intention to benefit the corporation. Now, the courts have read these two elements in very loose ways, so that to a lot of people, they've almost been read into nullity. So, for example, courts have applied respondeat superior to apply to an employee who embezzles money from the corporation to pay a personal politician friend. Why? Well, because the employee was technically on the clock while they were embezzling that money, and their job was in part to manage relations with the political branches. And there's some really roundabout way that this political friend could have a friend who would eventually end up helping the corporation. And so they found, yes, this corporation engaged in violations of election financing laws and was convicted of a crime. So you see how the intent to require, the intent to benefit, and scope of employment uh, prongs of respondeat superior have both been read in very liberal ways.
Yeah. So does it matter for criminal law how we treat, in quotations, minds of corporations? Do you think there's any problematic ways of attributing mental states to corporations, or is there some way of representing corporate minds that you think is the right way?
Yeah. As to whether it matters, I think that our view and the law's view on what corporate minds are makes all the difference. So I think and this now I'm just kind of stepping outside of the law. I'm just talking about Mihailis's personal view. But I think there's two things that we're basically trying to do in corporate criminal law. One is to reflect popular intuitions about what corporations deserve. I think this is part of what it means for criminal law to be legitimate. It means that it is democratically accountable and reflective of our shared basic norms and understandings about basic moral questions, including whether and when corporations are to be blamed, to be punished for what they've done. When we have a doctrine of corporate mens rea that allows for the kinds of inconsistencies and paradoxes that I just mentioned, those that we find deeply counterintuitive, I think the law is failing on this intuitions of desert prong. It also fails when it under attributes or over attributes culpability to corporations. So when it's just basically not connected to the ways that people ordinarily think about corporate responsibility. I think we want our criminal law to embody our shared judgments about corporate responsibility.
Mm-hmm.
The second thing I think we are trying to do, basic thing we're trying to do with corporate criminal law, is to, and this is something that Matt brought up just a moment ago, but is to give corporations the right sorts of incentives. So to consider what the policies we have in place will encourage corporations to do. Unlike natural people who have a very limited set of responses that they can make to the criminal law, like either I do it or I don't do it, corporations can arrange their internal structure. Basically, to think analogously, rewire their brains in ways that change how they, and this is now in quotation marks, think about the costs and benefits, the various considerations telling in favor or against different courses of conduct. And so one question we need to ask as we have a doctrine of mens rea in place is, will this approach encourage the corporation to implement systems that increase or decrease the incidence of crime? So let me give a concrete example. Suppose a law knowingly prohibits the installation of pipes that don't meet certain safety parameters. Okay? One corporation is installing pipes which end up exploding and killing some workers. There's now an investigation for homicide against the corporation, and the investigation reveals that the corporation has been very sloppily run. There were a group of employees who were installing the pipes and knew all about the technical parameters of the pipes. There was another employee who sits in the office, not in the field, but is sitting in the office, and knows all about the regulations and the different detailed safety requirements the pipes have to have. But the corporation doesn't have any channel of communication set up between the office worker and the people installing pipes in the field. Okay, so remember, this statute, and this is an example based off real life, this statute prohibits knowingly installing pipes that don't meet the safety parameters. Under a traditional application of respondeat superior, this corporation would not face any liability. because there's no employee in the corporation who knew that the safety standards were being violated. And my personal sense is that this result defies our intuitions about corporate responsibility.
Right.
It seems like this corporation did something bad. It seems like this corporation should be punished. If an individual did the same thing the corporation did, the individual would be liable, and we would feel that would be a right result. And this indicates to me the corporation should be liable too. So that's the first prong. Does it reflect our intuitions of desert? No. Respite is superior in this case does not. Additionally, this provides very bad incentives to corporations. Corporations looking at this result now know that they can immunize themselves from certain forms of criminal liability if they break down the channel of communication they'd need to have in place to prevent the pipes from being installed in a way which is inconsistent with the safety regulations.
Right.
Now, the approach to corporate mens rea that I prefer to respondent superior is one that's really responsive to the cognitive science literature about how we attribute intentionality and responsibility to corporations. So I really give primacy of place to these shared public intuitions about corporate responsibility.
Mm-hmm.
There's this concept in cog sci called mind reading. It works that we can't see each other's minds, and yet somehow we know when people intend things or know things. We do this very roughly by taking in external cues about people's behavior and circumstances and inferring what was going on in their heads. It's a hot day and I see you walking towards the fridge. I read in your mind that maybe you're feeling thirst and that you intend to get a drink of water or a cup of milk or something. And what cognitive scientists have found is that this kind of mind reading that we use for each other is exactly the same sort of mechanism and engage the same sorts of processes when you replace an individual with a corporation. We look at what the corporation has done and the circumstances in which the corporation has behaved and triangulate to the sorts of mental states that we would attribute to the corporation. And we do this even when we're making judgments of responsibility and assigning blame to the corporation.
Mm-hmm.
So my preferred approach to corporate mens rea would basically allow judges and juries to do that, to engage their natural and instinctive processes of mind reading. The same sorts of things that we ask judges and juries to do when it's an individual defendant. The jury can't look in the defendant's head, right? The jury is engaging in mind reading, looking at what the defendant did and in the circumstances, and triangulating to a mens rea. You can do the exact same thing for corporations. That's what the cognitive science literature has thoroughly persuaded me on. I think that this approach doubles down, fully satisfies the first prong of what we're trying to do with corporate criminal law, which is to reflect our shared intuitions
Mm-hmm.
about corporate responsibility. And for more technical, kind of like economic and business science reasons, I think it gives corporations the right incentives too.
Yeah, that's cool. We can now turn explicitly to the issue of corporate criminal responsibility. We've kind of already started talking about this to some extent, but what does it take for corporations to be criminally responsible? And are the requirements for that kind of responsibility similar to commonly accepted requirements for free will or moral responsibility in the individual case?
So the conditions for legal responsibility in corporations, as I said a little bit ago, are the same for individuals
Right.
and for corporations. You got to have the actus reus and the mens rea. On my reading, these legal requirements for responsibility, again, both for individuals and for corporations, are very different from my understanding of current philosophical approaches to free will and moral responsibility. My philosophy dissertation was on the philosophy of action. That's what I wrote about. And in the philosophy of action, you see, I was persuaded that there's this robust connection between action and responsibility, that we are responsible for our actions. Most people seem to agree with that. And what is an action in philosophy? Well, the standard definition of an action is that it's a behavior or a physical movement which is intentionally undertaken. And so if you just kind of follow A through B to C, we are responsible for the behaviors that we intentionally undertake. Now, that is a very different picture from the one that the law paints, even just restricting ourselves to criminal law. And on this point, I think personally the law gets it right. Under criminal law, and you had a little bit of this from your conversation with Craig, one of the mens rea that establishes the culpable mindset is intention, or sometimes the law will call it purpose. But in the federal criminal code alone, there are over 100 different responsibility entailing mental states that, if they accompany a behavior, establish your legal responsibility. So Craig went through some of these, right? Intention is one. Mere knowledge about the product of your action is another. Some philosophers seem to countenance that as being within the scope, perhaps, of intention. But then there's recklessness. Recklessness is just knowing about a risk and acting anyway. And then there's negligence. Negligence is not knowing about a risk and acting anyway. And then below that, we have various forms of strict liability, which is a kind of criminal responsibility that can attach in the absence of any mental state. I'll give a quick example of strict liability just because I think it illustrates a point that I'm going to make in just a moment, which is the felony murder rule. So murder is the most serious form of homicide that a person can commit, right? There's like manslaughter, there's negligent homicide. Murder is the worst kind of homicide. It's the thing that typically requires purpose or malice aforethought or something like that. You can be guilty of murder even if you had no purpose to kill, didn't know you were going to kill, and didn't even take a risk that you would end up killing someone under the felony murder rule. Felony murder rule states you can be guilty of murder if you cause a death while committing some other felony. So even if you were not negligent with respect to causing a death, the fact that you were committing some other felony at the time will make you guilty of murder if a killing results. Now, why do I think this is a really interesting example? It is an example of responsibility in the criminal law, in the absence of something that a lot of philosophers would think of as action, and yet syncs up really well with people's judgments about responsibility. The reason felony murder rule exists, and the reason most of our criminal law exists, at least our core criminal law, which brings all of these different mens rea as a responsibility entailing mens rea, is because they reflect our American Western common intuitions about responsibility and desert. And so when I look in the criminal law for some connection between action and responsibility, I don't see it. What I see instead in our democratically accountable criminal code is something which is much more permissive than what philosophers call action. And so if the question is, does the law's requirements for establishing responsibility match up well with free philosophical conceptions of free will and moral responsibility, the answer is no. But on this point, I think I'm inclined to go with the law.
Interesting.
So speaking of that, what kind of implications do you think this has for thinking about individual free will and moral responsibility?
Yeah, this is one of the things that really, when I started writing, so I finished. I said I finished. I didn't finish my philosophy degree before I started my job here at Iowa in the law school. I finished my philosophy degree the first year that I was here. But I got really interested in corporate criminal law about in that break in my PhD program. And for me, my favorite chapter of my dissertation was the first chapter, which is also the last chapter I wrote, which drew connections between, or what I thought were connections between, corporate criminal law, corporate responsibility, and individual responsibility. Not necessarily philosophically deep connections, but connections that were important for me as someone who is thinking through what the nature of individual responsibility is. Because as I read about debates and free will, I feel a lot of angst because, we're talking about the to a lot of people, and I think maybe to me as well, something that goes to the core of my understanding of myself and of everyone around me about what our value is and what our significance is to each other and what we owe to each other and what we owe to ourselves. And when I read skeptical arguments about free will, I feel like the walls are closing in. And my reflections on corporate responsibility have helped resolve some of my angst. The reason is this. As I mentioned before, we have, and they're very well documented, robust and long-standing practices of holding groups like corporations responsible, blaming them, and treating them as though they are responsible agents. And yet, outside of like a handful of people who are working on collective agency, most people, and I can tell you basically all lawyers, don't think that corporations have anything that amounts to free will. And what this suggests to me is that all of us have really two different modes of engagement with groups like corporations. We have a pragmatic mode of engagement where we're exercising our day-to-day judgments about the things that corporations are doing. We're blaming them for their violations. We're praising them for their accomplishments, and we are adjusting our relationships, both social and economic, to them on a day-to-day basis. And then we also have a reflective mode of engagement with corporations where we kind of step back and we think about all that stuff about whether it makes any sense. And most people that I talk to come to the conclusion as they're metaphysically assessing whether or not these day-to-day judgments have any real metaphysical grounding. The answer is no. They're just like corporations are literally fictitious people. And what this points to me is that there's a psychologically stable fictionalism afoot in how we relate to corporations.
Yeah.
We can't get rid of our pragmatic mode of engagement. Cognitive scientists have studied this, and they at least have persuaded me that these mechanisms we have for thinking of corporations as being responsible are pretty hardwired. Also, we're not going to get rid of our reflective judgments. If you're not persuaded yet that corporations are agents, you're probably not going to be.
Mm-hmm.
And yet we have this kind of stable way of balancing these two modes of being and engagement. And it doesn't resolve which one of them is right, but it maybe also means that we can get along and we can move on with our lives, even if we can't.
Mm-hmm. That's interesting stuff. Well, thanks again, Mihailis, for joining us to talk about this stuff today. And I'll recommend, I read a few chapter drafts of this element that you're working on for the Cambridge Element series. I'll recommend that for listeners to check out when it comes out. In the meantime, where can listeners go to follow your work?
So in legal academics, mostly post their scholarship open access to SSRN, the Social Science Research Network. So if you just Google SSRN and my last name, Diamantis, Diamantis, that'll be the first hit for you, and you can see all my work there. I also have a Phil Papers, Phil People profile. It's more sporadically updated, but you can also find a lot of my work there too.
Very cool.
Okay.
Yeah. Thanks again, Mihailis.
Thank you.
In our next episode, we'll talk about omissions and moral luck, and our guest will be Joseph Metz, assistant professor of philosophy at Widener University.